Okay, so talking about the scenario where a parent can actually lose their parental rights to their very own child, meaning this parent becomes legally as a stranger to the child and no longer has the right to guard the child, manage the child, be with the child, or do anything regarding the child at all. That does happen in the state of Texas, and we want to talk about the scenario that can present that outcome. So here is an example case that happened in 2018, but the ultimate decision was rendered in 2019. So this isn't exactly what you see when there's the state of Texas filing a brief on behalf of CPS to try to remove the child. So this is the Texas Department of Family and Protective Services. That's CPS filing a brief to remove parental rights. And so what are the facts that happened when this scenario arises? The parental rights to son NG were terminated after a trial before the court. They talk about the facts, and the brief is always going to have the statement of facts that kind of gives the background story. So we know that the child was about 4 years old when CPS came in to remove the child. It's said that the mother had been released from jail only a few weeks after the father had been arrested for robbery. So we've got two parents with criminal history, and the department made the decision to remove the child after the child tested positive for methamphetamine, and after the mother refused on several occasions to take a drug test from CPS. So when CPS offers to take a drug test, and what we saw and learned when reading these briefs here is that CPS counts that as an automatic positive result. So if you refuse a drug test, it's going to be, in that sense, as damaging as if you had just taken it and tested positive. But if anything, it's actually more damaging in this case to refuse it, because the department will mark down that you are not being cooperative, which ultimately can lead to the court deciding to terminate your parental rights as a factor in that decision. So this brief that was submitted by the department to try to remove the parental rights also said that the mother had a lack of coping skills. So we don't just have, when you read this brief, you get a picture that we're not just talking about a person who has a drug problem and a criminal history. Her reactions to what the department did played a vital role in the outcome of this case. So it's not just that mother had an issue, dad was also an admitted drug user, and he had said he did not use methamphetamines for about 6 months, and that he had not used marijuana for a month. So they know that he's using marijuana in the house, and they also noted, importantly, beside from the drug problem and everything, they noticed that the house was dirty and it was not a good environment. So when you do the interviews with CPS, they are noting down the state of your house, and the state of your house cleanliness and environment will be marked down possibly. Now, this is a huge part of this, what happened in this case, okay? Mother and father were provided copies of the service plans. Service plans. Okay, so when you have somebody call CPS, which is how these cases pretty much always start, somebody makes a call to CPS, CPS caseworker, child protective service worker shows up and they investigate things, and often the result of that will be that they're going to set up a service plan for you, okay? So they give you this list, this checklist of things that you have to do. And whether you decide to do those and how closely you decide to do those will play a huge role in the outcome of whether your parental rights are terminated. You need to create this make this service plan the most important checklist you've ever been given in your life. Regardless of all the mistakes that you may have made, this checklist is going to make a huge difference in whether and how everything proceeds from there. If they see that you're remorseful and that you do everything, you're going to be in a much better position. So they're going to give you a parenting class, a psychological assessment, counseling, a drug and alcohol assessment, maintain the fact that you have to get employment, and they're going to give you random drug testing and tell you to attend visitation that will be supervised with your child. You need to do all of those. And look what happened here. They listed everything that she did not do as reasons to the court, and this is the document that the CPS sent to the court. They listed all the things that she didn't do. And then the court is going to make its decision. The judge is making a decision whether your parental rights are terminated. So they cited all these things. And this, again, this is the citation that says failure to appear for a drug test was an automatic positive. That's how CPS treated it. So they always cited these things, taking responsibility for their actions, getting clean. They don't necessarily, it's not how CPS finds you that results necessarily in the termination. It's how you respond to their intervention, because they want to feel that they have intervened, helped you, and created a safe environment for the child and now can leave. They don't want the expense and burden of taking your child. They want you to become the safe environment, and they want proof that that has happened from what we see. Now, this is not my system or my setup. This is just us bringing information to you about what we actually see happening in litigation with CPS. So, with as far as the father, he wouldn't let them view his home, and so that was viewed as a point against him because he was being mysterious or whatever. He was being enforcing his privacy rights. He would not allow them to view his home, so they viewed that as a point against him here in this brief. And this was the kicker, though, in my opinion, that led to everything, to the end of the parental rights as the parents knew them, and that was that NG, the child, had a guardian ad litem, an attorney. A guardian ad litem is usually an attorney that is going to be investigating and talking to the child. And the attorney ad litem said that the child does not want to be with the parents and wants to stay in his foster placement. The child's own preference was expressed through this, even though the child, according to this brief at the time, was 4 years old. The court writes its own responsive opinion. The court takes this brief that we just looked at and looks at it and looks at all the evidence and then makes a final determination. And what they did was they said, this is the information we're looking at here. 5 months after NG was born, the father went to prison for 2 years. He was released, and then only a bit later, mother went to jail. What they did was they put the child, when the child returned positive for drugs, they removed the child from the parents and had the child go to grandmother. And that's what they're going to do a lot of the time with these CPS cases, is they don't want the child, whenever possible, to go to the state or to an unrelated foster parent. They want the child to go to the next of kin, an uncle, a grandfather, a grandmother, adult, somebody that's old enough to do responsible caretaking for the child, since obviously wherever the child is, it's not safe. So this is the decision of the court. This is what it looks like. And this is where they get into right here in the discussion. This is where we're getting into the law, the meat, the source that the court can use according to the statutes of Texas, that it has the right to terminate parental relationship. It terminated the parental relationship. That's a fundamental right. That power is just enormous. And here's the statute, what it says. Section 161.001B1, Section E, allows for termination of parental rights if clear and convincing evidence supports a finding that the parent engaged in conduct or knowingly placed the child with persons who engaged in conduct which endangers the physical or emotional well-being of the child. You can have your rights terminated if the court finds that you endangered the physical or emotional well-being of your child. That is a broad statute. It's very broad. That being said, in practice, these extreme circumstances where there's a criminal history, child says he doesn't want to be there, nothing coming to the rescue, that's where we see it actually happen. The psychologist who performed a psychological evaluation of mother. So now remember, mother is ordered to submit to a psychological evaluation, and she does. And she goes and she talked to the psychologist, and then now the psychologist is testifying against the mother as to what happened. So that should tell you that if you are ordered to a psychological evaluation, whatever you say to that person is not safe. The person may try to make you feel safe, but here it is in public information that is available to all of us, what happened during those meetings. And this is the final the final order, that the rights were terminated, according to the justice of the appellate court. So that was the outcome. So it's not one failed drug test that causes a permanent termination of parental rights. It is how you respond to CPS after that happens. This has been partisfriends.com. Thank you for stopping by.